Justin, welcome to Law on YouTube. Today we're going to cover an important topic, and that is preliminary inquiry hearings in Maryland. Now you may think, preliminary inquiry hearing in Maryland, that doesn't sound too interesting. Well, if you're facing a criminal case in the state of Maryland, it's an important thing to know about, because if you got such a hearing date notice in your mail, you need to act quickly. We're going to cover a few topics. First, what the heck is a preliminary inquiry hearing? Second, what do you need to make sure you have done before the preliminary inquiry hearing? And third, we'll just close up with some remarks. So first, what is a preliminary inquiry hearing in Maryland? Well, one of the primary purposes of the preliminary inquiry hearing is to make sure that the person that's facing the charges has a lawyer. Now you have three options in Maryland and every other state, one of which is very bad. So let's start with the bad option. The first option you have is to represent yourself. You could go to your preliminary inquiry hearing and inform the court that you decide to represent yourself. Now, if you decide to represent yourself, the court's going to have to go through a litany of questions of you to make sure you understand that this is a bad idea. You don't know the rules, you don't know the law. No matter how smart you think you are going to be a very bad lawyer. That leads to our other two options. The other option is, if you can't afford counsel, you can apply for the Office of the Public Defender, but you need to do this as soon as you get a notice of your preliminary inquiry hearing. You do not want to show up at your preliminary inquiry hearing and tell the judge that, oh, I had something to do, I didn't have enough time. The court wants to know that you take these charges seriously. Not that you admit that you did anything wrong, but to say, you got respect for the court, and it's a big deal to go to court. And you should take it seriously too, because you could go to jail and you don't want to do that. The last option, which is the best if you can afford it, is to retain your own lawyer. Number two, get a lawyer well before your preliminary inquiry hearing. Unfortunately, if you have a preliminary inquiry hearing in circuit court, that means that you've been indicted on a serious charge. So hopefully you have an attorney far before this, because odds are, if you hire a lawyer around the time of your preliminary inquiry hearing, the police have tried to talk to you, and there's an 80% chance that you unfortunately talk to the police and that will be used against you. But if you have a good lawyer, they can file motions to deal with that and address that in court. They can handle it. It's always better to hire an attorney as soon as you think there's anything wrong, and definitely before the police talk to you. What happens if you hire an attorney? Well, if you hire an attorney, they will have the ability to file electronically or in paper an appearance. Once they find the appearance, you don't even have to go to the preliminary inquiry hearing. The reason is, if your attorney enters their appearance, the court knows that you have counsel, so there's no need. You're protected. The court clerk will issue some court dates, and things will go in motion. Your attorney will get discovery. You'll go over strategies, defenses, motions to file, which is what we do in Maryland cases, and that'll be that. If you wait till the last minute, your attorney may have to actually go to the preliminary inquiry hearing and say they represent you, and you're going to probably have to pay extra money to waste your attorney's time. So if you get a preliminary inquiry notice, make sure that you have resolved whether or not you're going to have a lawyer before the hearing, if at all possible. Number three, in closing remarks from this lawyer in Maryland, who also has a partner who's in the other room. Her name is Miriam Z. Sadiq, owner of the law firm SadiqLaw.com. As Maryland lawyers, we always want to encourage, whether you're represented by us, represented by the public defender, or represented by somebody else we don't know, never ever talk to the police at any stage. We're talking about the preliminary inquiry hearing in Maryland, but hopefully you have retained counsel before that ever happens. If you're well before your preliminary inquiry hearing and the police are trying to talk to you, don't talk to them. If you are at a preliminary inquiry hearing stage, make sure you talk to that attorney so they can enter their appearance, not waste everybody's time. Plus, you're wasting valuable time for your attorney to try to get evidence in the case, review it, set up your defenses. I mean, if an indictment has been filed in Maryland and you're facing this inquiry hearing, you are looking at the distinct possibility of risking jail, a conviction that's going to affect the rest of your life. This needs to be the most serious thing in your life. Otherwise, could be in jail, or you could never ever get a good job ever again. How do we know that? Well, we get people that hire us on what's called a post-conviction. That's when things go bad, they don't handle their stuff, or someone's lawyer doesn't handle their case, and you have to go in and say their lawyer screwed up or something bad happened. Subscribe, like, ring that bell so you know when the videos are coming out, and leave a comment. If there's other issues you want us to cover, we're happy to share legal information to the best of our abilities. Again, no legal advice here. If it were legal advice, we would have a retainer agreement and we would be your attorney. Until next time, have a great day.